Today, we're going to pull back the curtain on the part of the legal system where most cases are actually won or lost. And here's a spoiler, it happens long before anyone ever steps foot inside a courtroom.
I mean, seriously, what if I told you that all those dramatic courtroom showdowns you see in the movies, they're often just the final act of a play where the winner has already been decided? The real battle, the real hunt for the truth, well, that happens much, much earlier.
You see, before you can even think about hunting for evidence, you need a map. In a lawsuit, that map gets created during a phase called the pleadings. This is all about drawing the battle lines and figuring out exactly what everyone is fighting about. It all kicks off when the plaintiff, that's the person doing the suing, files a formal complaint. Then the defendant has to file an answer, going through that complaint point by point to either admit it, deny it, or say they don't have enough info. After a possible final reply from the plaintiff, this formal back and forth sets the stage for everything that's about to happen.
And here's where it gets really important. Once this whole process is done, the battleground is officially defined. Anything that was admitted is now considered a fact. No need to argue about it. But everything that was denied, well, that's what the rest of the lawsuit is about. These become the issues of fact that need to be proven, which leads us right into the main event.
So let's talk about this evidence treasure hunt. And we're not talking about digging through dusty old law books here. Nope. This is an active, strategic search for all the little puzzle pieces that will either build or completely break a case. This, my friends, is legal discovery.
So what is discovery really? Well, to put it simply, it's the formal pretrial process where both sides get to see the other's cards. They get to use a specific set of 5 tools to get facts and evidence from each other, and sometimes even from people who aren't part of the lawsuit at all.
Now this phrase right here, this is the golden rule. It's like the secret password of discovery. Notice, it doesn't say you can only ask for things that are admissible in court. It says you can ask for anything that is reasonably calculated to lead to admissible evidence. And trust me, that is a huge difference.
What this really means is that discovery lets you follow the breadcrumbs. You're not just looking for the smoking gun. You're allowed to look for the receipt for the gunpowder, the map to the gun store, and the diary entry where someone mentioned thinking about buying a gun. You're hunting for the clues that eventually lead you to the proof.
Okay, so let's start with the first set of tools in your discovery arsenal. These are all based on the written word, and they are incredibly powerful for just laying the foundation of your entire case.
First up, you've got the request for admissions. This is, you could argue, the most powerful tool of them all. You send a written statement of fact, and the other side has to either admit it or deny it. If they admit it, boom, that fact is considered proven for the rest of the case. It narrows the battlefield in a huge way.
But you got to be clever about it. Look at this. If you ask one big, complicated question, the other side can just deny the whole thing if even one tiny part is wrong. The smarter play? Break it down into simple, individual facts. That way you force them to admit what's true, locking in their story piece by painful piece. Then you've got the request for production. This is exactly what it sounds like. It's how you get your hands on the physical proof, a formal demand for documents, objects, or basically anything that you need to get a look at.
And the scope here is just massive. I mean, we're talking emails and photos, obviously, but you could also ask for toothbrushes or even chainsaws. Seriously, as long as you can make an argument that inspecting it might lead to admissible evidence, it is fair game. The scope is just incredibly broad.
And the last written tool is interrogatories. The best way to think of these is like a written interview. You send over a list of questions and the other party has to give you written answers, under oath. Now the key here is that courts often limit the number of questions you can ask, so you have to make every single one count.
Okay, so that's the paper trail. But what about getting information from people directly? Well, the next set of tools is all about that face-to-face interaction, where you can actually see how a witness reacts when they're under pressure.
The key difference here is really simple. Interrogatories are written questions with written answers. A deposition, on the other hand, is live and in person. It's a formal interview where a witness is under oath answering questions out loud with a court reporter typing down every single word.
Now, the huge advantage of a deposition is that you get to read the person, not just their words. Do they hesitate before they answer? Do they start getting nervous? You can't see any of that on paper. The downside, of course, is that they're really expensive and they take a lot of time, so you have to make every deposition count.
But what if you need information from someone who isn't even part of the lawsuit, say a bank or a hospital? Or what if you need to force someone to do something, like go to a medical exam? Well, that's where court process comes in. You basically ask the judge for a special order, like a subpoena, to legally force that third party to cooperate. So now you know the 5 tools. But just having the tools isn't enough. Winning at discovery is all about using them in the right order, with the right strategy. It's about playing chess, not checkers.
So here's how the pros do it. You always start with the written tools. You send out your request for admissions to lock down the facts, your request for production to get all the documents, and your interrogatories for the basic answers. Then, and only then, you sit down and analyze everything you got back. It's only after you have all that information that you even think about conducting your depositions.
And why that order? It's simple. The goal is to eliminate surprises. By the time you actually sit a witness down for a deposition, you should already have the documents and answers you need to guide your questions. You should pretty much already know what they're going to say. You're just getting it on the record, or catching them if they try to change their story.
Which brings us all the way back around to the ultimate takeaway. When discovery is done right, it does way more than just prepare you for trial. In a lot of ways, it decides the outcome before you even get there.
Just think about what this quote is really saying. There's not one shred of evidence you can require to be produced at trial that you cannot obtain before trial. This means by the time a trial starts, there shouldn't be any aha moments. No surprise witnesses, no secret documents. A lawyer who has done their job right has already seen every single card the other side is holding.
And that leaves us with a pretty fascinating final question, doesn't it? If a thorough discovery process reveals all the facts and basically determines the winner, then why even have the trial? What is the courtroom really for? It kind of suggests that for many cases, the trial is less a search for truth and more of a final, formal presentation of a truth that's already been uncovered. Something to think about.